Okay, next on our agenda, it's in page 406 of your materials. We have the LLLT board proposed amendment to APR 28. Hopefully on Zoom, because I don't think they're here in person. We have our chair of the LLLT board, Nancy Iverin, vice chair Jennifer Bull, and the innovative licensing manager and regulatory counsel, RSD Jonathan Burke. Are they all there? I hope.
Yes, we are.
Yes.
Good morning.
Okay, good morning. I'm going to turn it over to you to decide who's going to talk first, or if all you're going to talk, or I'm going to let you organize your own presentation, okay?
Thank you. Also here with us is Steve Crossland, who is the incoming chair nominee and who has, of course, worked on the LLLT board since its inception. As you all know, the LLLT program was sunset. And so our request for these rule changes is designed to respond to the sunsetting and the new duties and lesser duties based on that sunsetting. Just a brief update on what we've done this last year. We created the tests for the final 2 LLLT examinations before the July 31st, 2022 sunset date. We also requested that the court extend for 1 year the opportunity for candidates already in the pipeline to obtain their experience hours, their 1,500 experience hours, because some of them, I believe there are 8 or 9 remaining candidates, were unable to get their experience hours because so many offices were shut down due to the pandemic. We continue to review and assess APR 28 as the LLLT program sunsets into its post-sunset role. And what we anticipate doing in the coming year is to continue to develop and update forms that can be used by the LLLTs, similar to those used, similar to the process of the LPO forms. We want to be able to develop CLEs in order to support the, I believe it's 76 currently licensed candidates. We want to make sure that because of their specialized license, that they are all up to date on the current changes in family law as it affects them. We would like to be able to develop a means to gather data and analyze the LLLT program, because we have not been able to do so without having the authority to require the LLLTs to at least give us some demographic data. And we also will continue to collaborate with the Access to Justice Board and the Practice of Law Board, both of whom we consulted with during this past year. The changes that we are requesting and the explanation for those are outlined in the letter or memorandum dated September 6th of 2022. And they include reducing the LLLT board size down to 11 members, to delete some of the responsibilities that are no longer relevant because we are not setting up any kind of educational or testing programs, nor are we proposing new practice areas. We wanted to amend APR 28C2 to include duties to process and administer LLT disciplinary grievances, approve standard forms, propose rules governing LLTs, and to establish committees to carry out the board's powers and obligations to both the LLT practitioners and to continue to protect the public by monitoring the LLTs. We are asking that because of the change in the law, the LLTs were previously allowed to do non-parental custody. That statute was repealed and replaced with the guardianship process. We are asking that LLTs be allowed to do guardianships, but only where the guardianship is related to the family law issue and it is unagreed or default matter. Under the prior non-parental custody regulations, LLTs were allowed to assist people through the adequate cause hearing. So this request to allow them to continue with the family law kind of guardianships limits them to only agreed or default. And we wanted to clarify that the LLTs may accompany their clients, but certainly are not representing them. There is no representation. They're there as sort of a technical assistance for their clients in settlement conference proceedings. So we're proposing this to the court, and we would ask that the Board of Governors give us their support, and I would be happy to take any questions.
Are there any questions? I know that Nancy Hawkins probably got questions. Any questions from the board members? Nancy Hawkins.
Well, Mike, I'm here to make comments, not ask a question of the chair. Would you rather complete the question process before hearing those comments?
I don't see any hands up, so you're
Okay.
up.
Thank you. As I mentioned in passing yesterday, the Family Law section is asking that the Board of Governors table this item until the completion of the, and I won't try and repeat the title of the taxi cab policy. We believe that there should be a policy completed that spells out the responsibilities of the Bar Association, the Board of Governors, the staff, to these Supreme Court created entities, so that we have, there are limits or controls or at least educated decisions about staffing, which costs money, as well as the out-of-pocket costs that these kind of programs require. And it's just inappropriate to be starting to pull these these Supreme Court created entities out one by one, let them expand their cost duties, and then try and mop up the problem later. We need to have that taxi cab policy. We heard yesterday that it is likely to come to the board in November, and so that this matter should be tabled until then. We also have, and obviously I can't make a motion, but would ask someone if they agree to consider that motion. Substantively, we also see issues with parts of the LLT board's proposal. Of course, it's up to them if they want to reduce their board numbers. That seems like a logical step at this point. But the proposal goes forward and talks about new powers And almost all of them, to me, without a fiscal note from staff, look like they're going to cost more money. The LLLT board's going to now be responsible for what would, if this was adopted, be responsible for educating their members. Well, those of us who put on CLEs know that CLEs don't just involve volunteer time from our section, they involve staff time. So now we're talking about CLEs that are going to be specially designed for under 80 people statewide. We don't know what they would, how they would be educated differently from other family law CLEs, but surely it's going to cost staff time and out-of-pocket costs. And there's no fiscal note. In fact, the fiscal note with this proposal is that it will likely reduce the cost of the LLLT board. And that just frankly doesn't make sense when you take on additional duties. They talk about increasing their scope of practice. And of course, we've been through this before. Expanding their scope of practice has been rejected a number of times. And without a more clear policy, the taxi cab policy, for example, it would seem that they could propose any number of increases in their scope of practice. I think one of the sentences that I had most concern with and would urge your attention to is adding the power to the LLLT board to collaborate with other boards and entities regarding the delivery of law-related services. Well, that's pretty broad. It goes far beyond the work of LLLTs. And we would be putting in the hands or encouraging putting in the hands of under 80 people, people who are not lawyers, to basically, it would seem, speak for the Bar Association with regard to delivery of law-related services, apparently even beyond the scope of the LLLT practice. I believe that the Bar Association should be dealing with other boards and entities and organizations about the delivery of law-related services. That's a laudable goal, but it should be done as an organization. It shouldn't be left to a board of 11 people out of 72 or 74 or 76, depending on what the source is for the current number of LLLTs. That's handing over a huge job, a very important job, to 11 people that we would have no role in choosing. Substantively, the proposal also talks about replacing the ability to work on non-parental custody cases to working on guardianship cases. And you probably can remember over the last year or so, periodically, I would talk about, in the legislative context, this new Uniform Guardianship Act that completely is upended family law with regard to third parties. And I can assure you that this guardianship statute is absolutely nothing like third-party custody. It is a very complicated, multi-step process. It is being worked through very carefully by judges, by the family law section, by local bar associations. It is quite complicated. It is not simply a renaming of a prior statute. And I think that it shouldn't just be thrown in here as if it's just renaming a current statute. It also adds duties to the LLLT program with regard to settlement conferences and personally, I don't think you can do an adequate settlement conference if you're not an experienced litigator, because you judge what's reasonable for settlement based on what courts might do. And I just don't think the LLLT program is there. I've never understood why the LLT program should be responsible for its own discipline. We spend lots and lots of money on a discipline process for investigating complaints. And I don't see how a group of people that is this small should be responsible for basically handling the complaints of their coworkers. I apologize. It'll stop, or maybe somebody will grab it. It's just, like the family law section doesn't discipline its own members. Why should the LLT program discipline its own members? These things should be done independently, separately, and in a process that is governed by its own rules and regulations. I've always been concerned about the forms issue. But again, we're talking about expanding a process that will undoubtedly involve staff time, and there's no fiscal note that goes along with it. So our primary request to the Board of Governors, besides my comments, is that this be tabled pending a taxi cab policy or whatever other name someone with an older dictionary comes up with, so that we have a newer dictionary, I'm not sure, but an easier dictionary where we know what this organization's responsibilities are to the Supreme Court created entities, so that the Supreme Court understands the fiscal impact or lack thereof of these various boards, so that they can all be treated appropriately. We already know that there were issues raised with the request for additional multiple staff by one of these entities. This is real money. You toss around a couple of $1,000s, pretty soon you're talking about real money. And so we would ask that this be tabled until we have a more comprehensive policy, and then can address more of the substance of the policy. Thank you.
I'm going to ask again if any governors have any questions, comments. I'm going to turn it back over to the, Governor Clark, I'm sorry.
I'd like to make one that we actually do not support this. I believe that the comments that were made lend me to believe that we should vote no on this. And if you don't feel otherwise, and not agree, I think doing the tabling makes sense.
I'll second that motion.
Is that a motion, Governor Clark?
Yes.
Tell me again what the motion is.
So the first one that I would make is that we vote no on this. And if that fails, then I'll make one then. I mean to wait. So.
Yeah,
So
and we don't approve or disapprove, right? Executive director, we kind of like, what do we do?
Well, ultimately, this can go directly to the court, and the LLT board doesn't need the Board of Governors support to do that. But so I'm interpreting the motion as Governor Clark moved that the board not support this proposed amendment. Is that accurate? Okay.
Does the second agree with that?
I was interpreting it, but I guess we could ask Dan that he's moving that we recommend denial of this request to the court.
Yes, that was my.
That was okay. So with the motion being as I've just stated it, I do again second it.
Okay, so it's been moved and seconded that this board not recommend or actually recommend denial of the amendments to APR 28. Any discussion? I'm going to let the board the Triple LT folks speak to this too or talk about it. Don't think you're getting left out of the loop. Oh, good. I see the chair's got her hand up. Thank you. So we got Brent Williams Ruth first, and we've got Governor Stevens on the phone, and we've got Chair Iveren.
Thank you, Mr. President. And I just need a little clarification because my mind's a little foggy. So is the motion that we actively submit to the court that we're opposing the proposal from the LLT board, or are we just not joining in on supporting it?
So I would oppose it.
So actually send to the court saying we oppose.
Personally, and if not, then the second piece, then either way, but yes.
Thank you. I just needed to understand exactly. So we're actually, the motion on the table is that we'd actually oppose the motion of the court. Okay, thank you. That was all. I just needed to clarify. Thanks.
Sorry, Governor Stevens.
Thank you, Mr. President. So I guess I'm also trying to understand what the practical effect of this would be if in fact the Board of Governors voted in favor of this motion, meaning that would not stop the LLT board, if I understood you correct, Executive Director Nevitt, that would not stop them from proceeding to the court with their recommendation. And so if they did that, we would then, and I'm sorry, I'm just asking the practical effect, we would then write a letter to the court saying we oppose and we urge you to not approve this request. Is that the practical effect if we voted yes on this?
I'm going to let Executive Director Nevitt jump the line and give a little clarification.
Yes, I think the LLT board can, regardless of what action we take here, the LLT board can send the amendment directly to the court. So my understanding based on the most recent clarification is that if this motion is approved, then we would send a letter to the court on behalf of WSBA that urges them to not accept the amendments or to deny the amendments. And then I also have a comment that I can wait.
Governor Stevens, you have anything else you'd like to say for or against the motion?
No, I just needed that clarification.
Okay. And I think I've got the chair of the LLT board up next, I believe, plus followed by Governor Dresden.
If I could, I would like a couple of the board, well, our other board member, our assistant chair, and Steve Crossland to comment on a couple of those issues. If I could get Mr. Crossland to talk about the collaboration with other boards, specifically that we're looking at ways to assist with access to justice, not to expand any of our LLT practitioners' roles in that. But for those of you that don't know, there are many other states, and I'll let Mr. Crossland address this, that are emulating and developing programs very similar to ours. And also the Legal Services Corporation, which funds nationally all of the legal aid programs, is looking at our model for providing related practitioners to assist with the access to justice, particularly in rural and underserved areas. So I don't know, Steve, do you have comments on the collaboration and outreach?
Yeah, thank you, Nancy, and thank you, board. Yeah, just a couple of quick comments about the motion. First of all, this is really an administrative thing, and Nancy's comment, Nancy from Family Law comment that this is a big sweeping change. It's not. It's merely reducing the size of the board, which will reduce the cost to the Bar Association in administrative costs. And the other thing is that, as I understand it, Nancy and Jen, you can clarify this, that the change in the guardianship law, it's merely restating what LLLT has been authorized to do prior. So it's really cleaning up the APR 28 to make sure that we all understand that what they're doing is well within the bounds that were authorized by the court when APR 28 was approved. In terms of the collaboration, I don't think this is something that's clandestine or anything. We have been collaborating with the ATJ board and the Practice of Law board since the inception of all those boards. We all feel, as we hope that the Bar Association would also feel, that we're about providing access to justice. And so we want to not be stepping on each other's toes and be supportive of one another and collaborative. So, for example, as you probably are well aware, the Practice of Law board is discussing a sandbox idea, which has been implemented in Utah and a couple of other states. And I think these are all good things. And I think we've said on the LLLT board that we're all about access to justice. And I don't think we ever thought that this was the sole and only answer to providing access to justice, but it's one of hopefully many that are being discussed, which Nancy, you made mention. This is something that's happening all across North America. Colorado and Oregon are in the process of implementing Washington LLLT type rules. Utah and Arizona and others are also implementing programs that are a little less stringent than the Washington program. Minnesota, and as recently as yesterday in a roundtable discussion, New Hampshire and Connecticut are also discussing this. Provinces in Canada, Manitoba, Saskatchewan, British Columbia, Ontario are all studying and implementing similar type programs. So I hope that those of you on the board that fear that this is some wild and crazy idea that is destined to corrupt the world will take a look around and understand that there are many, many jurisdictions around North America that are trying to find different ways to implement ways to provide access to justice. And so I'm going back to the motion itself, which is to oppose the idea that we reduce the board to 11 does not seem to make much sense to me. And the idea, the second part of the motion, as I understand it, is to simply, to use a word but not directly applicable, recodify APR 28 from the way it was when APR 28 was written to allow LLLTs to do the type of practice that's now codified under the guardianship statute. Just doesn't make any sense except to just oppose the idea of LLLTs. So I hope all of you governors would either vote to support this idea or just leave it alone. It's going to go to the court and we will make our pitch to the court. But we hope that you will see that what's being proposed is not disruptive in any way.
And if I could address the issue of the guardianship and non-parental custody, Jen Bull is on our board and is a LLLT and also a paralegal with 25 plus years experience working in family law, and her practice has included doing non-parental custody and also providing a clinic at our local volunteer lawyer program, Law Advocates, for those grandparents who were seeking assistance with being able to assist their children by taking care of their grandchildren. So Jen, do you have some brief comments on that issue?
Sure. So my name's Jen Bull. I'm a LLT for those of you who I haven't met before. Since 2010, I have been one of 4 staff members of the Kinship Custody Clinic at Law Advocates in Whatcom County, where we help family members or non-family, which we call fictive kin, get some kind of legal custody of children. This was a kind of a passion project of mine on the LLLT board, because what we see in our clinic is the vast majority of referrals come from DCYF. The vast majority of clients report that the reason children are with them is because of a DCS placement. And they're actually referred to our clinic from DCS. Right now in Washington, well, the estimate from 2020 is over 75,000 children are being raised by someone other than their parents. And I think it's 1 in every 11 child in that estimate, there is no legal guardianship of any type. So what we do is we help people get this legal rights for the children so they can take them to doctors, put them in school, get them any number of services, access Social Security for children who have deceased parents. And really, we're not asking for anything else. We're asking for the same thing we had when 2610 was repealed in January of 2021 and replaced with the minor guardianship statutes. These would still only be in agreed situations, which the bulk of what I see in this clinic in the last 12 years, they're agreed. Someone else has had these children, the majority of these children's lives. Or in a default situation, which is also what we see a lot of because the parents are just gone and no one knows where they are. Also under the Keeping Family Together Act, which went into effect in June of 2022, there will now be this goal in dependency cases to keep children with family placements that they've been with rather than moving them somewhere else. And one of the resolutions to the dependency is for someone to file for guardianship. So we're likely going to see an increase in need of assistance with these family placements getting guardianship in place. But we're really not asking for anything to be expanded, just replaced. It would be the same situations where they're agreed or by default. And most of these referrals do come from the state. And it would really help with access to justice, especially for these children, 75,000 plus children.
Okay, just a quick addition to the comments, and that is that the LLT board, we do have the authority to require education of the LLTs, and putting on the CLEs would actually be a way to generate revenue for the program. We are reducing the cost significantly by not only reducing the number of board members, but also by reducing the number of meetings and just scheduling the majority of our meetings to be virtual. So we anticipate significant cost savings, and we hope to be generating revenue with the CLEs. Thank you.
Thank you. I see that former President Crossland, former Chair Crossland, soon to be Chair Crossland of the LLT board again has his hand up. Is that, did you want to say something else?
Very briefly, yeah, thank
Okay.
you. And the introduction is longer than my name, so maybe I need to add my mother's and grandmother's name into me. I just wanted to comment on Nancy Hawkins' comment that this should be deferred to be dependent upon the decision with regard to taxi cab. That may be moot based upon the motion that's now been made, but I will briefly comment it. Having been part of the taxi cab group for almost a year now, I really think, in my view, and Tara and Kyle, you may view this differently, that's about policy. policy of the Bar Association, the Supreme Court, and the Supreme Court boards. And what this motion is about administration of this board. It's really taxi cab, and what comes out of taxi cab will not address these issues. So I just think that's really kind of a red herring argument. But again, it may not be relevant with regard to the motion as it's posed.
Thank you. So I've got several people in the queue here, so I'm going to tell you what the order is. We got Executive Director Nevitt next, then Governor Dresden, then Nancy Hawkins, then Alex Stevens, and then Kyle immediate past President Schicchetti.
Two quick comments, one on substance and one on process. Just from the role of the staff that are administering the program, I think there are a number of changes in here that are pretty neutral and could serve efficiency. So I think there are some good things in here that are worth looking at. And then from a process point of view, I also think if the board is going to vote to oppose these, it would be more valuable to the court to be able to articulate why. And so I think we need to give I would encourage you to give some thought to how the letter will be prepared, what its content will be. And then another thought to consider if the board wishes to oppose these is to do that during the comment period, which will inevitably follow after these are proposed to the court. And that would give the board a little bit more time to articulate its reasons for opposing the changes.
And I have a slight correction to the order. I missed, apologize in advance. I missed Governor Higginson. So it's going to be Governor Dresden, Nancy Hawkins, Alex Stevens, Carla Higginson, and then Kyle. So the floor is yours, Governor Dresden.
At last. Executive Director Nevitt actually anticipated a lot of what I was going to say, but I have a couple questions that are maybe in the form of comments. The first one is, and it may be another process. I think it's another process question, but as former President Crossland indicated, they're going to go. The LLLT board is going to go to the Supreme Court regardless of what we do, and the idea of tabling this seems to me is, I'm just not sure what purpose or what value that would be, as it would just. I guess my question is whether we would even have the opportunity to take action later if we table, because it seems to me that they're going to the Supreme Court. That's my first question.
Can I respond?
Executive Director Devitt.
So I think, and again, and feel free others to correct me if you think I'm misstating this, but I think potentially there could be two opportunities to influence either the LLLT board or the court. So if the board took action today, then that's an opportunity to influence the LLLT board before they send it off. It's also an opportunity to influence the court before they decide whether to publish it for comment. So that would be the value of acting now, is you'd have those two opportunities. If you table it or wait, then assuming it is published for comment, you could still comment on it before it's adopted, unless the court did some kind of expedited approval.
Thank you, Executive Director Nevitt. My second comment, I guess, is just that I guess I would suggest that there are certain things in here, even for those on the board who oppose this. There seem to be some things in here that are unobjectionable, such as reducing the size of the board. And I guess I would propose that there may be a room for some more nuance to the vote of not just reject, like if we do reject it, say why, and then maybe say, but we do support these certain things within it. That would be my suggestion.
And for the primary, I'm not myself as one thing, I guess, speaking personally, I do think that the board should be reduced. I would say the board should be reduced more than 11. I believe that the LLLT board, there is a
a court rule that the Supreme Court used to vote to sunset this, and that's GR 25.E. And that specifically requires that a limited license has to be revenue cost neutral. It is not, it is still not. And so I guess the reason that I am making the motion that I am is that part of what they propose does not seem to be sunsetting. It seems to be wanting to undermine what the court has done to go to other states to say Washington is wrong, and that is what they've done in the last few years. And I mean, speaking personally, it was not well taken at all, trying to get there to be op-eds to say shame on you. So that's not what the courts. I mean, the court made their ruling. We should respect that. So thank you.
I think I have Nancy Hawkins up next. You're up.
And just to confirm, we did suggest that reduce the number of the board was not objectionable. The point raised by Dan just now is also a good one, that going around the country is, and part of the reason, a significant part of the reason that a number of these other areas are even considering a paralegal program or triple LT program is because our program was described by Mr. Crossland and others in other jurisdictions as a model for success, which it was not. It was a financial failure, and it did not serve enough people to make the expenditure of money worthwhile. And that was eventually an opinion that was agreed to by a number of people, including members of the Supreme Court. So the idea that they would continue to go around and talk about, how hardworking the current triple LTs are, and that Washington made a mistake, et cetera, is the same as comments I've heard about the board considering suing the Bar Association for opposing the program. So we should not be paying for people to attack us when the reasons why this program was sunsetted are valid. We've spent the last year in the ethos process and in other years, I mean, it's been an ongoing issue about worrying about the feared lawsuits over the subject matter of work of various aspects of the Bar Association. We've all heard the word germaneness, and yet this proposal appears to say that Triple LT board can go anywhere and say anything, and it doesn't matter. They don't have to meet the same standards that sections do or other entities have to do. And that's a big issue that needs to be resolved within the taxi cab consideration. Because does anybody really think that if somebody's going to file a lawsuit because of something that a Supreme Court created board or entity came up with, that they're not going to sue the Bar Association for it? Are they going to see a difference that they're some separate entity? They are not. So, we're all lawyers around the table, or just about all of us. The Bar Association would be sued in the feared lawsuits that Julie's been rattling our heads about for a few years now. If one of these entities does something that is within their power, but was not approved by the Bar Association. So we need to address that. I appreciate that Nancy believes that CLEs put on by the CLE board are going to raise money. But I've put on CLEs for my section. Most of us have for our various sections over the years. It's not as easy as saying, okay, well, we have 74 members. We'll charge them all $100, profit $7,400. There's costs. The Bar Association takes money for it as well. And it's just, again, a lack of real attention to the fiscal details. There's just not enough people in the LLT program to really make a profit on CLEs. Now, does that mean the family law section has to include some of its product, its CLE product for LLTs? Probably, and it's my understanding that we've done so and that the bar has done so. But that gets it to a bigger audience and makes the subject matter broader. And I totally agree that there are huge issues with regard to third-party custody. And we opposed the elimination of the third-party custody laws. And there are lots of kids that need court orders, and we want them to have court orders. But it is not the same legal process. It has completely different notice requirements. It has exceptions to some of them. Is anyone aware that you have to give notice to the actual child unless you meet one of the exceptions? There's different pleadings. It is not as easy as just doing things the way that used to be. And longtime family law lawyers are struggling with those changes. So it is complicated, and I do think that we should be writing a letter. Frankly, if the board doesn't want to write a letter, the section will want to submit a letter during the comment period dealing with the substance here too. But I think it's an end around proposal and to try and get around some issues that should have been decided. And frankly, it's not the path to access to justice. Access to justice is free, competent legal services, whoever provides it. But it needs to be free or closer to free than an existing program that's been sunsetted. And I for one, am tired of the guilt trip that we are opposed to access to justice because we are critical of some of these ideas.
Okay, folks, I hope you'll keep your comments to new information. We've got starting to get a little bit repetitive, and we do have the deans of the law schools here to talk to us, and I'd like to get them on before we have too much more time pass. But right now I've got Governor Stevens, Governor Higginson, past or immediate past President Schicchetti, and then we've got Jonathan Burke, and then Governor-elect Kading, and then former president, former chair, soon to be chair, Crossland.
Mr. President, I've taken myself out of the queue. I would only second Nancy's comments, and in being mindful of your admonishment, I don't need to repeat those. So thank you.
Thank you. All right, Governor Stevens.
Thank you, Mr. President. And while it's not very uplifting, I appreciate some of the recent comments that are being made that's kind of behind this motion, which I will be voting no in terms of opposition. But I think it raises, and I would hope, and I believe that the new president will engage with the court on our behalf with the executive director on what sunset means. Because I think that is in some ways where the rub is. I'm going to pose this motion because I actually would like to have the LLT board submit its proposal to the court. And I think during the comment period, we can raise a number of questions, but I think one of the underlying questions really is, what is the court's expectation and what should anyone else have as an expectation regarding the existence of LLTs? what is the expectation and what is the court's direction regarding the existence of the LLT board? Does sunsetting mean that actually all LLTs are suspended? I'm asking those questions because on the one hand, I think some people could say, well, there's a sunset, but we have this group of LLTs that have been licensed, and I actually am in support of people who were in the pipeline to actually that were grandfathered, as I recall, when the sunsetting happened, but have not been able to actually move forward during COVID. But that doesn't overcome, I think, the underlying issue on whether or not LLT should exist at all, whether we should have a board at all, should things just go away? And I don't think they should, but I think the court, having decided to sunset, needs to give more direction. You know, because I heard some of my colleagues being quite exorcised when the executive director and the WISBA staff provide support to this existing board, which I think is their responsibility in terms of WISBA and all of the Supreme Court boards. But this becomes a real hot issue when it has to do with LLTs. Well, I think that's again because we have different expectations and different interpretations of what sunsetting means. So as I was listening to this, I was saying, well, what are LLTs supposed to do? Those who are already licensed as LLTs, what are they supposed to do? What is their role supposed to be? When there's a change in law that impacts them, do they go forward or are they out of the process whatsoever? But I think the underlying part about that is what we believe sunset means, what we believe is the not just the right, but if they are to exist, how do they exist? How does WISBA support the existence? Because actually, as I'm hearing it, it's almost like, let me do everything in my power to cut off all oxygen, all, and I'm using analogies, of course, but all oxygen, all flow of blood to the LLT program. And I'm going to do that, even though it's not clear. I think there's a difference between sunset and sundown. I think there's a difference between the gradual ending of a program and the immediate cessation of a program. But I think it's now time to sort that out and ask the court to sort that out so that we all understand that. But because of that, I don't think we should actually take a position whatsoever in this way. We're just going to oppose what's done, but instead let them make their submission and let us raise, I think, the important questions that need to come along with this. Because I think, at least for me, that's where we go back and forth regarding the LLT program, LLTs, what should be done, what can they do, what ought they do, what support should WISBA provide for the existence of the LLT program, understanding that no new LLTs can begin the process. So those are my comments. Those are my concerns, but I'm going to vote no because I actually believe I'm going to vote no on this motion because I actually believe we should have at least on the one hand, neutral position, and on the other hand, raise questions that I think are underlying some of the reasons why this motion has been made. Thank you.
So I'm trying to cut off the discussion so that we can have our esteemed deans here tell us what's going on in the legal education world. They've been very patient. So yes, Governor Clark.
Okay, one thing that I was just said that I want to make sure to, I'm going to clarify emphatically, the triple LTs that are licensed, they're members here, they are valued members. I am not saying, and I do not believe anybody is saying, they should be sunset. What the sunset is for new ones. Okay, so that, I mean, that needs to be emphatically stated. They are members of our bar, they are valued members. But I think the real crux is, and the reason that okay, I've made this is part of the proposal is to continue to either expand or, in my opinion, to potentially challenge the sunset. Okay, so thank you.
Media Past President Shigetti.
Thank you, President Collison, and I'll be very brief. I understand we're short of time. Clearly, the Board of Governors has concerns with elements of this proposal, but I think to reject it in whole would be seen not helpful to the court and might be seen as reactive and perhaps even retaliatory. I think the much better approach would be to wait until the comments, they're going to comment to the court or pitch their proposal to the court, the rule changes, and then we would have an opportunity to address those specific concerns that we have and our position behind it, and be much more persuasive by doing that, and the court would find that much more helpful. Just rejecting it at this point might send the wrong message, and I really want us to send the right message, carefully worded, so the court would have something to work with. The reason why I wanted to speak, however, is taxi cab has been mentioned a couple of different times, and I think President Crossland is right, and and Nancy's also right, that there are issues that do touch upon taxi cab. I don't think it's this one. This one, taxi cab will identify the processes. There's a dispute resolution clause that we're working on, and President Crossland has been very, very helpful for that process, and I appreciate his work on over the last eight or 9 months, and that will continue. But this one wouldn't involve taxi cab because, again, it's a proposed court rule change, and the process for that would be comment to the court, and then the court would make a decision regarding that. So I don't think taxi cab ever comes into play for this particular issue. In other issues and other boards, it might, and that's the balancing of the independence and the role of the Bar Association. But that's not this issue. Thank you.
Governor-elect. Oh, I'm sorry. I'm skipping. We got our innovative licensing regulatory officer, Jonathan Burke, who'd like to speak. Oh, you got to turn on your mic. Yeah.
The record, yes, I'm John Burke. I'm the staff liaison to the LLLT board. I just wanted to focus on a few facts here. One of the most important is that the WSBA fiscal analysis said that this proposal would save money, approximately $4,000. So that kind of is in response to the, I guess, the arguments that what we're asking for, or what the LLLT board is asking for, will increase the cost. And if there's a delay in this, that means that if the proposal was delayed for going to the Supreme Court, that would be another year, almost 2 years before there would be those realized savings. There's statements over and over again that the purpose of, as stated in the memorandum, is to acknowledge the sunsetting and to implement and transition from what the board was doing before as to what they will do in the future, because of the sunsetting, there was a comment about our board reaching out to other states, and just in my role, a couple days ago, I received an invitation from the state of Arizona asking, could we provide someone that would be able to give them some information about the LLT program? So it's not the LLT program or board reaching out to other states. They're reaching out to the LLT board and finding out what can they do that to make sure that whatever program they adopt is it works. And so I just wanted to clarify a few things there. I think everyone else has stated the other things I was going to, so I'll end it there.
Thank you very much. Governor-elect Kading.
Thank you, Mr. President. I just had one comment regarding this, and of course, I'm relatively new at this. But it appears that the paragraph D substantively changes what the Bar Association is responsible for, because it talks about the LLT board's duties and powers, including providing continuing legal education to LLTs. And before it looked like it was approving education, and I wonder if providing continuing legal education and then having the bar provide reasonably necessary administrative support for that creates any issues. And this is based on yesterday's budget discussions that we heard. And also, I was just wondering if the Bar Association had any input in crafting the language of this proposed rule change. So that I was just wondering if that is a substantive change that would potentially lead to additional costs for the Bar Association. Thank you.
To save time, I'm just going to say Steve Crossland.
Thank you. And I'll try to be very brief because I certainly don't want to be under the bad graces of the deans of the law schools. Real quickly, Jonathan Burke has clearly stated that this will not only be fiscally neutral, it will save money. And so, Eric, I think in response to your comment, I think we took that into consideration in that analysis. To speak to Alex's comment, which I think Dan commented on, and I appreciate that, Dan Clark. Alex was wondering about the future existence of the LLT program. And to remind everybody, LLTs that are licensed now, they have a license from the state Supreme Court, the same as all of us who have JDs who passed the bar exam have. And in fact, their first induction into the profession was at the Temple of Justice with all of the Supreme Court justices present and welcoming them and swearing them in. So for them, sunset does not mean those that are licensed now would lose their jobs. They cannot. They have a license. To do so would be a taking on the part of the government. I want to comment briefly, about Nancy Hawkins about what we need is more free legal services. That hasn't ever been the mission of the LLT program. It's to serve a huge needy subject or portion of our population of consumers of legal services, which our Supreme Court studies have identified. At least half of our citizens in our state earning 200% to 400% of poverty level, nearly half of those people cannot afford legal services. And those are people that have an income of $100,000 or less. So let's not mistake what this is about. And finally, and going back to the motion and going back to our proposal, which will go to the state Supreme Court, this should not be a referendum on the idea of LLT. This is merely a proposal by us to the state Supreme Court to tweak APR 28 to make it more relevant for today. 9 board members, and make the scope of practice with regard to now codified in the guardian statute the same as it always been. So I just think we, I'd love to have a discussion over a grand period of time with all of you about the virtue of the LLT program, but that isn't what this motion is about. And final note, I thank you, John. We have never reached out to other jurisdictions except in one instance. 3 years ago, we created a roundtable discussion, and once a month, nearly 70, 80 people are on the list, meet and discuss these ideas. Not that they're great ideas, but find out from other jurisdictions why they think it's a good idea or why it ought to be otherwise. It's nothing more than a think tank, but it is a not insignificant think tank. And also the program out of the University of Denver Law School, ILS, is convening a session in early November to create a paper on this whole movement. And I think that will be helpful and instrumental for all of you as members of the Board of Governors. And
Steve Crossland, I got to cut you off.
I'm done.
I think you're going way beyond the scope of the motion.
So yes, thank you.
Okay, we got to vote, folks. I'm sorry. I think you've gotten a lot of information. You can make a decision one way or the other. I'm going to have the executive director or secretary restate the motion before you vote, so you know what it's all about.
The motion is that the board recommend that the court deny this proposed amendment.
Everybody have that motion in mind? Okay, Governor Abell.
Aye.
Governor Adwale. Not here. Governor Angelville. Not here. Governor Boyd.
No.
Governor Clark.
Aye.
Governor Couch.
No.
Governor Dresden.
Aye.
Governor Higginson.
Aye.
Governor McBride. Governor Peterson.
Yes.
Governor Pertzer. Governor Siani. Governor Stevens.
No.
Governor Williams-Ruth.
No.
I'm doing my math correctly. I have 5 yeses, 4 nos. Is
Yeah.
that what you have, Executive Director Nevitt?
Yes,
And the rest of the folks not voting?
correct.
So by a bare majority, the motion carries.
President Tollefson, just for clarification, because I can't remember, what is quorum?
8.
Thank you.
We have 9. Okay. I want to thank the members of the LLT board for their patience in listening to all of this stuff, and they probably got some good information, and I don't know if they want to make use of it or not make use of it, but I thank you for your patience and being here today to make your presentation. Appreciate it very much.